to be invited to talk to you all on a topic like federalism, which I think is highly contemporaneous, more for the challenges that it is facing in the present times. I also would like to remark that for the same reason for which Justice Muralidharan could not have been invited till 2026, I thought I will not also be invited till at least after 1 month when I am going to retire. But let me assure you that I'll try not to lull my conscience too much. I wish that each state had a member in Rajya Sabha or in Lok Sabha, like Mr. John Brittas, who could espouse the cause of Justice Muralidharan, because there are a number of judges from many states who face the same fate. For example, Justice Qureshi, and many others like that. We talk about only the higher judges who lost the opportunities. There are several unheard and unsung maladies of the judges who are there in the lower rungs of the judiciary. My concern is more for them, because these so-called judges occupying the higher positions are imitating the same procedure which rejected the opportunities for them. Let us think more about them. Federalism as we understand, let me also make one disclaimer before I come in speaking on the topic. Though I functioned as a judge of the constitutional courts for 4 long years, I did not have an opportunity to deal with any case in which federalism as such was involved. But both as a judge of a high court and as a judge of a district court, I dealt with hundreds and hundreds of cases in which the federalistic aspects within the meaning of federalism in which I understand came up before me. Federalism as we understand is only about division of powers between the center and the states. Apart from other aspects like bicameralism, supremacy of the constitution and independence of the judiciary, so on and so forth. Federalism is not a new concept which is introduced for the first time by the Indian Constitution. It is as old as 4th century BC, when Aristotle in his works has described the 3 organs of the state. The ancient Roman Republic also followed the same concept. In the modern times, Montesquieu has made it more systematic and scientific in his work, The Spirit of Law, which has influenced the founding fathers of the United States for drafting the US Constitution, which was the first constitution in the world in 1789. So we had the vision of 4 constitutions before we drafted our constitution. Our constitution did not start on a tabula rasa. So we had the vision of these 4 constitutions. The US Constitution, as already said, 1789. And then the British Parliament Act, the British North American Constitution, 1867, and the 1900 Commonwealth of Australian Act. And then we have the Government of India Act, both 1919 and 1935. So our constitution is modeled on the Commonwealth of Australian Act and the Government of India Act, for the reason that the US Constitution and the Australian Constitution did not have fully blown lists. They had only 2 lists with very enumerative subjects, whereas the other 2 constitutions had fully blown lists, 3 lists with a long length of lists. We know that federalism allows for accommodation of diversity and regional autonomy within a larger political unit, as said by just Mr. John Brittas, which is a very important aspect of federalism. Indian Constitution establishes a federalism with some unitary features, for which reason it is termed as a quasi-federalism. Dr. B.R. Ambedkar, at the time of drafting the Constitution, has remarked that the draft Constitution is meant both for the Union and also the federalism, meaning to say that we had a flexible federalism from day one. The reasons for leaving that flexibility for the federalism, perhaps going by the spirit with which the Constitution is drafted, must have been to make it more effective. Unfortunately, now that flexibility is being pushed to realize the vested interests of the governing bodies. We have, as already said, the federalism, the word of federalism is not used in our Constitution, but the Constitution lays down a structure for the government to function in a federalistic mode. And federalism has risen to the level that it had to be recognized as a basic structure of the Constitution. The Supreme Court in Satpal versus State of Punjab had upheld this principle, and the Indian federalism evolved from a unitary system under the British rule. And during the course of this evolution, it had to face several challenges like integration of the princely states, reorganization of the linguistic states, sharing of resources, the regional movements, demands for autonomy, interstate coordination, so on and so forth. We have various kinds of federalism, like holding together, coming together, asymmetrical. Ours being the holding together federalism, where the powers are shared between various constituent parts to accommodate the diversity in the whole entity. Powers are generally tilted towards the central authority. Though the Constitution speaks about the powers between the 3 organs of the legislature, executive and the judiciary, the legislature occupies the first position and is placed in the first place for the reason that it makes laws and it holds the purse. The executive, which holds the sword, is supposed to implement the laws and execute the will of the state. And the judiciary is to interpret the laws and declare the law and act as a watchdog of the democracy and guardian of the Constitution. In Ram Javage Kapoor versus State of Punjab, the Supreme Court reiterated that the federalism is a part of the basic structure of the Constitution. That was a case filed by 6 persons who were carrying on the business in publishing, printing and selling the school books. The Punjab government, in pursuance of its nationalization, issued notifications regarding this publishing and selling of the books, which consequently resulted in restriction of powers of the petitioners. So when the petitioners approached the Supreme Court said that no restriction can be placed on a right guaranteed by Article 19, Clause 1, Subclause G by mere executive orders without proper legislation. And that legislation also is held to be conforming to the Article 19. We have Article 73 and 162 in our Constitution, which are analogous to Section 8 and 49 of the Government of India Act, which deal with executive powers of the Union and the states respectively. It was observed that our Constitution, though federal in its structure, is modelled on British parliamentary system, where the executive is deemed to have primary responsibility for the formulation of the government policy and its transmission into law, though the condition precedent is to retain confidence of the legislature branch of the state. So the executive function comprises both the determination of the policy and as well as carrying it into execution. Under Article 53, Clause 1, the executive power is vested with the President. But under Article 75, the Council of Ministers with Prime Minister as its head has to advise the President, thus making the President a formal constitutional head. The real power of execution lying with the Cabinet of Ministers with the Prime Minister as a head. Likewise, the same system at the level of the states with regard to the powers of the governor. So the Supreme Court commented that therefore we have the same system of parliamentary executive as in England, a hyphen which joins and a buckle which fastens the legislative part of the state to the executive. The cabinet enjoying the majority is in the vested control of both legislative and executive functions. So not going further deep into the facts of this particular case, it would suffice to say that though the Supreme Court has dismissed the petition in that case, it held that the executive government is bound to conform not only to the law of the land but also to the provisions of the Constitution. So even if the acts are deemed to be sanctioned by the legislature, they can be declared as void if they are found to be unconstitutional and arbitrary. So the core objectives of Indian federalism are unity in diversity, as already said, and also decentralization in administration. So through federalism, the state pursues the goal of common welfare in the midst of wide diversity of socio-cultural and economic spheres. There are several issues challenging federalism. One such is regionalism. We hear that the cry for cessation of the states is taking the center into jitters. Why so? It is said that the more the number of the states, the more the center will be caught hostage, and it has to yield to the pressures of the foreign countries. The example of West Bengal is stated. West Bengal threatened this Teesta Waters Treaty with Bangladesh because of its potential costs. If regional power grows, it is understood that they may affect effective foreign policy, as the federal government may bow to the will of the individual state. But I think that what is followed for the states which are in existence as of today can be followed for the states which are increased by division. So however, the powers of the union and the state are specifically enumerated in the list. This foreign affairs is within the purview of the central list. So regionalism can be controlled when a sense of unity is promoted among the states. If the policies of the center are made in a way to make every state self-sufficient in terms of resources, finance and political stability, the states would not be forced to claim any vested rights and create problems. It is only due to the lack of proper policies strengthening the state administration that the states make separatist cries. So any international policy is adopted for the welfare of the whole country at large. In making such policies, the interest of the state should be considered when there would not be any conflict between the center and the states. So fiscal federalism should be evolved in a manner suiting the interests of the states. So the constitution, we know, vests the center with greater powers of taxation. Imbalances between center and states should be corrected by the Finance Commission by determining the share of the states in the central tax revenue. Both the vertical and the horizontal imbalances should be addressed where revenue do not match the expenditure at different government levels and different regions of the country. So this asymmetrical sharing of the revenue and resource crunch results in uneven development across the country. If care is taken to strike uniformity and sufficiency, regionalism can be subdued if not controlled. We are provided with indestructible union with a view to protecting unity and integrity of the country. This is thought as an arrangement which checks the growing demand for secession from Indian Union. In my opinion, creating checks for secession by constitutional impediments or otherwise will not improve the health of a nation. The needs for secession should be addressed so that there would not be any voice for secession. So in spite of all the challenges, federalism continued to be the most suitable form for a vast and pluralistic country like that of India. But restructuring Indian Federation, it can be made more effective. Impartial allocation to states, irrespective of the political considerations, and making the National Development Council more energetic and effective, and implementing the recommendations of the Administrative Reforms Committee that the Council should meet twice a year. NDC emerging as a verbal and effectual gadget of center-state decisions in matters of development would address certain challenges. So uneven economic development and under-representation of some regions should be taken care of so that narrow-minded and anti-national forces can be contained. So independent judiciary, as is already dealt with by Mr. John Brittas, is one of the features of the federalism, apart from separation of powers and other. It's a central element of a democratic system. It's a unique feature which separates India from other countries. However, time and again, the independence of the judiciary has been facing challenges. Protecting judicial economy begins with the constitution governing the court. So judicial independence must also be continuously protected against unforeseen circumstances. For the prosperity and suitability of the country, we know that rule of law is very important. Maintenance of rule of law is possible only by an independent and impartial judiciary. Apart from these two challenges, we have another challenge which comes through religion. Religion has now become a big threat for the federalism. Justice Muralidhar is here. Namaste, sir. So I have heard about a very interesting thing on this religion. Recently, when I was listening to a debate of one parliament member, a female member, she was questioned on the incident where one of the female film directors, Leena Manimekalai, if I remember, she had made a film called Kali, in which she played the lead role. She released a poster of Kali smoking a cigarette with a LGBT flag in her hand. You all know that this aroused lot of outrage from all sections of the society. When this particular parliament member was called upon to express her opinion on that, an interesting thing came to be known to me personally, that Kali is offered whiskey and other things as prasadam That's their tradition. This was really a news to me. Not only Kali, but there are instances where few gods are offered with whiskey. Kerala also. So what would have happened if instead of a cigarette, that director had kept a glass of whiskey in her hand? I'm sure that the same outrage would have been there. So we don't believe basically that the prasadam offered by us will be consumed by the deity. We don't believe in our practices. We don't analyze about our practices. We have certain stereotypic understanding about how our God should be. She further said that God is an imagination of each individual. We were made to learn that God is not only for human beings, for the whole universe where we have several creatures. If ant has to imagine God, it will imagine God as a bigger ant with perhaps thousands of antlers or thousands of heads. Likewise, any other creature. So when we are under an imagination about a particular thing, curtailing the imagination of few people with your stereotypic belief, I think is unfair. If something goes wrong, if something is unlawful, if something is illegal, you have a right to curtail. But if with the same freedom with which you are allowed to practice a particular practice, if somebody else comes out with that freedom, it's unfair for anyone to raise voice against it. And it's more deplorable that those kind of voices are being backed by institutions, more particularly the governments. That is what really concerns us. I think understanding the aspect of secularism in a broader sense, in coordination with the other aspects of freedom, would better help the society to forge ahead. All the religions, each religion teaches only about tolerism. But now we are seeing the intolerism practiced by each of the religions. So when we are raising ourselves to practice tolerism and to think a while before you attack others, then I think the secularism will be better addressed. And let us talk about, I am concerned more about this. Justice Muralidhar is here. He is a director, elevated to the High Court maybe, but with all the zeal he has, because he is our teacher in Judicial Academy for several years, we could understand his zeal and understanding about the lower judiciary also. With all that, I am sure he'll accept with my opinion that federalism at the micro levels is very important. If I have any problem, I will not go to the Chief Minister or the Prime Minister. I will rush to the local police station. If I have to fight out my cause, I will go to the local court, which is the lowest court in the ranks of the judiciary. So I need these institutions to be strengthened. I am not really concerned about whether the Supreme Court is strong or High Court is strong. I want this Taluk Court to be strong. Who has to make this strong? We are talking about judges who do not get their deserves, not getting their elevations in time. I remember my colleagues also being very much worried about their elevations when our panel was sent to the Supreme Court and the government. I used to question them, have you given all the promotions in your unit on time? Just do that. You'll get your share of the democracy. Try to put everything on track from the lower rungs. If you mold the system from the base, this is the base. The lower courts are the base, the lower institutions are the base. There's a saying called Yada Raja Tada Praja, but I say Yada Praja Tada Raja. It's what you demonstrate that you need is what you get. It's not compromising on what you get that's going to satiate your needs. Everyone should be able to rise to that level where you can ask for strengthening the micro level institutions. The circles of influence now at the micro level institutions is the concern. We know how the micro level institutions function. They feel the supremacy. Each one of them feels a supremacy. So this is injected by the people who are in power. We were always, when we went to Judicial Academy, we were taught that you are not going to achieve any power by becoming a judge. You are only taking up a responsibility on yourselves. So try to be conscious of that. When alone you will be able to discharge your functions as expected by the society. So friends, my appeal to all of you is, if you at your individual levels strive to put the things which are at your disposal on right track, it will take care of everything. Let not the salt lose its flavor to raise a question as to who is going to salt the salt. Thank you.